Let's first take a look at the ratification of the amendment, because this is a matter of controversy that got me into a lot of trouble for raising it in the Reconstruction chapter of my American history book. But I'm only repeating a totally mainstream interpretation. I found it hilarious. People had never even heard of this before. The argument that the 14th Amendment was not constitutionally ratified. I mean, the old National Review used to just take this for granted. I mean, old conservative publications, libertarians, all understood this. In the 1950s, U.S. News and World Report published an editorial saying, of course, we all know the 14th Amendment wasn't legitimately ratified. I mean, this was just sort of common knowledge. Now I say it today, and I get like Max Boot saying, oh my gosh, where did Woods get this crazy idea? Like I just invented it. Sort of funny. Well, let's look at what is the claim being made here. There are a few factors to take note of when we look at the ratification of the 14th Amendment. First, we have the fact that the amendment was proposed in Congress, and two-thirds of the people present voted to approve the amendment, and then it gets passed. It gets sent out to the states, and then 3/4 of the states have to ratify the amendment for it to take effect. Well, one thing we can note about the passage of the 14th Amendment is that it was not, shall we say, entirely without blemish. At the time that the amendment was set to be voted on and discussed, John P. Stockton was a newly elected senator from New Jersey, and he was known to be an opponent of the 14th Amendment. And he duly took his seat in the U.S. Senate at the beginning of the 39th Congress. Well, informal canvassing of senators made quite clear that there was no two-thirds majority in favor of the amendment at that time. In fact, it turned out that the amendment would have been one vote short of passage. So, a motion was introduced not to seat John Stockton. But he's already been seated. This is the problem. He's already been seated. So you can't really vote not to seat somebody who has been seated. If he's been seated, and you want to get rid of him for one reason or another, you have to vote to expel him. But expulsion requires a two-thirds vote. They didn't have a two-thirds vote to expel him. So they voted not to seat somebody who had already been seated. Okay? I mean, it's sort of like, how can something be both A and not A at the same time and in the same manner? So they voted not to seat this man who had already been seated. And then they went ahead and voted to approve the 14th Amendment. Now that's, it's really not legal. It's right, not a proper procedure. But that's actually the least of the problems associated with the amendment. Then it goes out to the states. Now Tennessee ratifies the amendment. But here's how Tennessee ratified the amendment. The problem that was occurring in Tennessee was that opponents of the amendment were refusing to show up at the State House and thereby preventing a quorum. Okay, I mean, you have to have a certain minimum number of people present in order to conduct business. Well, opponents of the amendment thought one way to prevent its ratification is just not to show up, and then they wouldn't have a quorum. Well, in order to get a quorum, two of the anti-amendment Tennessee legislators were actually kidnapped and forcibly brought to the State House and declared to be present so that the vote could take place. Now, there are some sticklers, who think that kidnapping is immoral, who would throw, some doubt on this, the legality of this. And the thing is that when the House Speaker called the roll, well, these two representatives refused to answer. They refused to say they were present because in their mind they weren't, spiritually they weren't present. They were only there, under duress. I mean, really by force. So they refused to answer the roll, but nevertheless they were declared present so that the amendment could be ratified. In Oregon, there was a situation that was at least as irregular as that one. In Oregon, you had a case where the legislature of Oregon voted on the amendment, and they voted to approve the amendment. But then it was discovered that two of the Republicans who had been elected in Oregon had actually not been legally elected. When they actually looked again at the votes, it turned out that Democrats had been elected in those two seats. So two Republicans were removed, replaced by two duly elected Democrats. So some people thought, well, we should re-vote on the amendment now that we have the legitimately elected people present. This time they voted not to approve the amendment. But they were told by the federal government, sorry, we take your first answer. Okay. New Jersey. Now, New Jersey and Ohio, the irregularities there are, it's not quite so clear cut. I mean, obviously in Oregon, there's no excuse for that. And in Tennessee, there's obviously no excusing that. New Jersey and Ohio is not quite so clear cut, but arguably there's at least some kind of irregularity here. Because both of these states rescinded their ratifications. And they rescinded them, though, before the amendment went into effect. It was still being voted on by other states. I mean, you could argue that if the amendment has already gone into effect, and then you vote to rescind your ratification, it is probably too late. But arguably, they may at least have had some right to withdraw. But they were told once again, sorry, we take your first answer. And New Jersey in particular, at the time that they attempted to withdraw their ratification, they actually announced, they said that we are fearful that this amendment has been worded ambiguously with deliberate intent so that in the future it can be used to deprive us of our liberties. Very interesting. Well, the most fundamental reason, though, that there was an illegality involved here is that here you had the southern states, which they ratified the 13th Amendment in 1865, abolishing slavery. No one had any problem with them then. 1867 rolls along. The radical Republicans in Congress, who are the wing of the Republican Party who favor, a very harsh settlement with the South, now that they're in power, in 1867 they declare other than Tennessee, they like Tennessee because Tennessee ratified the 14th Amendment, but other than Tennessee, the other former states of the Confederacy, the other 10 states, were declared in 1867 to be illegal, without legal governments. And they're going to be militarily occupied, they're going to be divided into 5 military districts, they're going to be deprived of self-government, they're going to have, in effect, military courts open. So that was all declared in 1867. That was said about the southern states. But at the same time, these same states were told you have to ratify an amendment to the Constitution. Now they're trying to have their cake and eat it too. Because either they're legal states or they're not. If they are legal states, then you shouldn't be occupying them with the military. If they're not legal states, then you can't ask them to ratify an amendment to the Constitution because they're not legal states. I mean, you may as well ask France to ratify an amendment to the U.S. Constitution. It would be perfectly irrelevant. So in other words, you're depriving them of all the privileges of statehood, but nevertheless you're going to impose on them one of the burdens of statehood. You're going to actually demand that they ratify an amendment to the Constitution when you yourself have just said they're not even legal. The states, as constituted in the South, are not legal. So it's been argued that therefore their votes could not have counted. In no way could an illegal state, by definition, that vote for the amendment be counted as a vote in favor of the amendment. I mean, that's not to mention the coercion involved here. I mean, there was one congressman who said that when the 14th Amendment was sent out to the states, Tennessee approved it, but the other 10 southern Confederate states rejected it. It was a northern congressman who said, well, the southern states have rejected the 14th Amendment, so we're going to march upon them at bayonet point until they do ratify it. Well, most legal principles would have it that a decision that you're forced to make under duress is not legally binding. So we have that difficulty as well. And for these reasons and even several others, very recently, like early 1990s, Forrest McDonald concluded that the 14th Amendment was never constitutionally ratified.